Most people think probate is just reading a will and handing out checks. It's not even close to reality. I've helped hundreds of families in the Carolinas avoid probate, and I've seen what happens when people don't plan ahead. In this video, I'll show you exactly how probate works, what it costs, and how to keep your family out of it completely. Let me start with what probate actually is. Probate is the court-supervised process that happens after someone dies. It's how the legal system validates a will, pays off debts and taxes, and distributes what's left to heirs. If there is a will, the court needs to formally accept it, appoint the personal representative, and oversee every single step they take. If there is no will, the estate is considered intestate, and the state law determines who inherits. This can get messy pretty fast, especially for blended families or complicated family situations. In both North and South Carolina, probate requires filing multiple documents, sending notices to heirs and creditors, and reporting asset values to the court. All of this becomes public record. Anyone can look it up. Probate is not automatic. It requires active oversight, strict deadlines, and compliance with court procedures. One misstep can delay the entire process for months. Now let me walk through the actual timeline with you. Probate is rarely quick, and that's a major problem when beneficiaries need access to funds or when properties need management. Here's what's involved. First, the will gets filed with the probate court. Then the court appoints the personal representative and issues letters testamentary. It's a legal document that gives the personal representative authority to act. Next, the personal representative has to identify, collect, and safeguard all estate assets. That's bank accounts, real estates, investments, personal property, pretty much everything. Within a set period, the personal representative must file an inventory of assets and their values with the court. Then, creditors must be formally notified. In South Carolina, there's an 8-month minimum creditor claims period. That means the estate has to sit open for at least 8 months while creditors can make claims. During this time, the personal representative has to pay outstanding debts, final income taxes, and possibly estate taxes. Only after all debts are settled can the personal representative seek court approval to distribute assets to the heirs. The entire process typically takes 9 to 18 months. If there's a dispute among heirs, however, problems with creditors, or delays in selling real estate, it can take even longer. I've seen estates drag on for 2 or 3 years. Now let's talk about cost. One of the most frustrating parts of probate is how expensive it is. Even a simple estate can rack up thousands in legal and administrative expenses. Here are the common costs: court filing fees, publication costs for public notice to creditors, appraisal fees for real estate or collectibles, attorney's fees, especially if the personal representative needs legal help navigating the process, accounting fees for final tax returns. A $1 million estate could easily lose $10,000 to $30,000 in probate-related costs. These expenses come directly out of the estate before your loved ones receive anything. So not only does probate take time, it takes money. Here's something important to understand. Not all assets go through probate, but many do if planning has not been done. Assets that go through probate include individually owned bank accounts, real estates titled solely in the deceased person's name, vehicles without a transfer on death designation, and personal property like jewelry, furniture, or collectibles. Assets that do not go through probate include property titled jointly with rights of survivorship, accounts with a named beneficiary like IRAs or life insurance, assets owned by a revocable living trust, and transfer on death or payable on death accounts if they're properly set up. The key is how each asset is titled and whether a legal mechanism is in place to bypass probate. Most people don't realize that how you title your assets matters just as much as having a will. So how do you avoid probate? If you want your family to skip the delays and expenses of probates, you need to plan ahead. The most powerful probate avoidance tool is the revocable living trust. When you transfer assets into a trust, your trustee can manage and distribute them privately without court oversight. That means no probate, no public record, no delays. Other helpful strategies include beneficiary designations on retirement accounts, annuities, and life insurance, payable on death designations on bank and investment accounts, and joint ownership with rights of survivorship, though this can create its own issues if not planned properly and discussed with all relevant parties. These tools work best when they're coordinated under a single unified estate plan. A mismatch in beneficiary designations or outdated documents can create confusion and trigger probate anyway. It's also important to revisit your plan periodically. Life events like marriage, divorce, a new child, or moving to a different state can affect your estate plan's effectiveness. Now here's the bottom line. Probate is time-consuming, public, and expensive, but it's not unavoidable. With the right estate plan, you can keep your family out of court, maintain privacy, and ensure your legacy transfers efficiently and as intended. At Rankin Law Firm, we help individuals and families design estate plans that avoid probate and preserve peace of mind. If you want to protect your family from probate process, schedule a consultation with us today. Links in the description. And if you found this helpful, subscribe for more practical legal insights that help you plan smarter. I'm JP Rankin. Thanks for watching.